So another federal court just found that the federal laws against possessing machine guns and convictions relating to that are in fact a violation of the Second Amendment. So let's break down what just happened in this huge decision. Now, before we jump into this video, I just wanted to ask you guys, if you want to support the channel, please consider subscribing. Also, if you're interested in some channel merch and apparel, check out the link down below, TriStar Trading Co. I have my own merch, and you can also pick up shirts like this one, the Shall Not Be Infringed shirt. They have amazing two-way apparel, a lot of apparel for other creators. So if you're interested, check them out using my link down below. So like I mentioned in the intro, another federal court just dismissed a machine gun possession charge using the Second Amendment and also the Supreme Court's recent 6-3 decision in that Bruen case. Now, this is the second time that we have seen a federal district court dismiss a machine gun possession conviction based on a finding that this federal law does violate the Second Amendment. This is a new ruling which came out of a Mississippi federal district court. It came from Judge Carlton Reeves in a case called U.S. versus Brown. However, this new decision also cites heavily to another case that we've covered here on the channel, which is the U.S. versus Morgan case. And that case came in a federal court out of Kansas, and the court there also ruled in a very similar way, finding that a machine gun possession conviction and charge was in fact also a violation of the Second Amendment. We are now seeing more and more federal district courts in decisions in different jurisdictions which are striking down the federal application of this machine gun law and convicting people simply for possessing machine guns. Now, in this Brown case, the judge stated that Section 922(0) makes it illegal to possess a machine gun unless the machine gun was lawfully possessed before the date this subsection takes effect. As Judge Brooms explained in U.S. versus Morgan, the statute criminalizes the mere possession of such weapons without regard to how the possessor uses them. If an individual purchases such a weapon and locks it away in a gun safe in his basement for 20 years without even touching it, he is just as guilty of a violation of 922(0) as someone who takes that same weapon out into public and displays it in an aggressive manner. So here he's pointing out how this federal law does not distinguish between, how someone's possessing the machine gun or how they're using it. Simply the mere possession of it in violation of the federal law can lead to a conviction. He goes on to state that Section 924(a)(2), meanwhile, is the penalty statute. It says a person who knowingly possesses an unlawful machine gun can be fined, sent to federal prison for 10 years, or both fined and imprisoned. Mr. Brown now asked this court to dismiss his indictment. Because he was never convicted of a felony, he argues that the Second Amendment protects him from criminal prosecution under these statutes. He is, in other words, bringing an as-applied challenge to his prosecution. The judge in this case then goes on to say Mr. Brown's argument was once foreclosed because of decades of precedent, not anymore. In 2022, the Supreme Court established a new historical paradigm for analyzing Second Amendment claims. Every appellate court's prior precedent was rendered obsolete. Under the new standard, the government must prove that its desired firearm regulation or restriction, which here means the statute criminalizing simple machine gun possession, is consistent with the nation's tradition of firearms regulations. This is a heavy burden, the judge states. He then moves on to looking at the Morgan case, also in his own decision. He states that the government found this out the hard way in Morgan. There, Judge Brooms observed that as Congress did not ban machine guns until 1986, the modern ban is inconsistent with the history and tradition. Even today, in fact, it is perfectly legal for a person who has not been divested of his firearms rights under some other provisions of law to acquire and possess a machine gun. He then goes on to state that the Morgan case may be deemed to be an outlier, but it's still relevant. Now, I also want to stop here because this is also in some ways important. The judge here in the Brown case is pointing out how the Morgan legal battle out of Kansas, that was decided by a lower court in a very specific way because the federal government there, just outright failed to provide historical justifications under Bruen for their whole machine gun restrictions. They did not present any historical evidence. They didn't even try to apply Bruen. And because of that, the judge in the Morgan case ruled against the federal government. Now, the judge here in this Brown case is pointing out that the Morgan, decision came out in a similar way, but there was really no historical justifications or analysis that happened in that case. And he's stating that in this case, in the Brown case, the federal government tried to justify this machine gun conviction based on history and tradition, but ultimately he also finds that here the federal government also fails. When reviewing the federal government's justification in this case, the court stated that Most of the government citations for these arguments are judicial decisions that predate Bruen. Many of its remaining claims, which focus on the benefits to public safety of a machine gun ban, are policy arguments entitled to no weight at all. The historical justifications the federal government presented in this case, included things like the Statute of Northampton relating to riding or going armed offensively to the fear or terror to good citizens, but the judge here rejects those historical supports, and he says that they do not support Mr. Brown's conviction of possessing a machine gun. He states that these examples might support the prosecution of a person charged with terrorizing others with a machine gun. Yet they provide no support for the prosecution of Mr. Brown. The government does not allege that he did anything against the public peace. Mr. Brown was not armed offensively, nor was he attempting to terrorize the good citizens. He wasn't going or riding anywhere. The government's briefs instead admits that the machine gun was in his home. None of the government's proffered historical regulations, however, are relevantly similar to criminalizing possession of a firearm in one's home. If anything, the American history and tradition support Mr. Brown's possession of a firearm in his very own home. Bruen nonetheless tells us that there is an American historical tradition of prohibiting the carrying of dangerous and unusual weapons. That is the law to be followed. The ultimate problem for the government then is this one here. Although machine guns are dangerous, it does not explain how machine guns are unusual. So here the judge is actually applying Bruen and looking at whether or not these are dangerous and unusual items. It has to be both dangerous and unusual. He finds that logically almost every firearm could be deemed to be dangerous because of course they're firearms, but the government also must show that they're unusual. And here the judge finds that the government did not meet that burden. The judge states that the Morgan case raised by Mr. Brown says that there were over 740,000 machine guns lawfully possessed within the United States in just 2021. 740,000 is no small number. The government presents no argument or explanation for why such a large figure is somehow not common. To contest that number of machine guns in common use, the federal government relied only on a Fifth Circuit case called Hollis. However, that case is now invalid because of Bruen, and also the number of machine guns presented in that Hollis case and in that record were only about 175,000. However, now with Bruen and the clear counting of over 740,000 machine guns, the Hollis case was found to be unpersuasive, and the judge here in the Brown case rejected that precedent. The judge stated in this Brown case that here the government made no attempt to present facts and figures. It placed all of its eggs in one basket. The notion that Hollis is still good law. Hollis, however, may not be good law. He then states that all of this should end the discussion. If Hollis was abrogated, then the government has no footing to stand on. The government has failed to meet its burden of establishing that machine guns are both dangerous and unusual. Under Bruen, it therefore cannot restrict Mr. Brown's possession of one of them within his home. The judge then concludes by stating that at their core, the Supreme Court's recent Second Amendment cases are predicated upon a lack of trust. The Heller, McDonald, and Bruen decisions did not trust that local and state lawmakers had protected their citizens' Second Amendment rights or would protect them going forward. The decisions also expressed doubt that the federal courts were doing enough to protect those rights. New boundaries were then set. The judge here is hinting at maybe he doesn't like the Bruen analysis and maybe he thinks it kind of muddies the water when you're looking at history and tradition because people can interpret it different ways. But regardless, he's saying this is the precedent, I have to apply it, and I find that this conviction does violate the Second Amendment. Now, this is only an as-applied challenge that is relevant only to Mr. Brown and his conviction. However, as we saw with the Morgan as-applied decision out of the Kansas court, these two cases can now be used by other individuals to reverse or challenge their own convictions. This decision also has a lot more force because the federal government here tried to justify the law using history and evidence. And, the Morgan case really didn't do that. The federal government did not present those types of evidence in that case. Here they did, and yet they were still rejected. Now, this will also be likely appealed just like the Morgan case was appealed up to the Fifth Circuit, but now you will have a Fifth Circuit case and now a 10th Circuit case here with the Brown case, being reviewed by circuit courts on whether or not these machine gun possession convictions do in fact violate the Second Amendment. So a huge decision, a significant case that we're going to be following. If anything else develops, if anything else changes, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by ARM scholars, and this nation will be maintained by ARM scholars.